Good evening. I'd like to call the meeting to order. This is a special meeting of the Lowell Conservation Commission. Today's August 6th, 2013. The only item on the agenda tonight for this special meeting is the Lowell Conservation Commission's response and consideration of a proposed settlement agreement and final order of conditions. Project location being 48 and 104 Townsend Ave and 800.1 and 800 Varnum Ave. The Lowell Conservation Commission will review a joint response to Conservation Commission comments provided July 11th, 2013, and a joint motion by the Mass Department of Environmental Protection and the Community of Khmer Buddhist Monks, or CKBM, for a summary decision relative to a proposed settlement agreement with a final order of conditions between Mass DEP and CKBM. Following review, the Commission will have the opportunity to provide a formal response to the motion. I'd like to set a couple of ground rules before we begin. If you have a cell phone or a noisemaker or some sort of electric device, please turn it off or turn it silent if it goes off during the meeting. I will ask you to leave. The second thing is there's a request from one of the parties to this matter for a joint answer or a joint response with the Conservation Commission. So I'd like to take that matter up first, but I want folks to be mindful and the Commission to be mindful that during the actual consideration and going over of a joint response, I'm not necessarily going to be taking comments. It'll just be a commission meeting. We may, or individual commission members may, request information from those in attendance for clarification if we need be, but I think since we've had a formal request for a joint response from abutters and the Pawtucket Citizens Committee or Council, what is it? Council, that we should respond to that and at least hear the position and any opposition or anything in support of that. So what I would like to do then first is, since we do have a formal request to consider that, and since Mr. Hamblett, since you made that request, I'll ask you to approach the podium and advocate your position.
Thank you, Mr. Chairman. My name is John Hamblett, 495 Varnum Avenue. As a point of clarification, the two groups are the abutters group, and those people must actually physically abut the property. And some of the members of that group are here tonight. And the other group, Mr. Chairman, is actually a 10 citizens group. We had 10 days to file our appeal. We did not have time to present this to the Pawtucketville Citizens Council. So while many of the faces are the same, for the purpose of legal proceedings, the class of that party is a 10 citizens group, as it's defined in the wetlands regulations. I have three general areas I'd like to discuss tonight. First is a process. The second are the issues for a resolution in the appeal. And the third would be our arguments. As I've said to some of you before, I am not an attorney. I am not a wetland scientist, and I am not an engineer. I'm representing two groups who feel they're going to be impacted by the proposed activity. I saw the process tonight as having 6 steps, and some of these could be handled at another meeting. We did file for an extension, and we didn't receive it. So originally our response was due this Thursday, the 8th, and now our response is due on the 15th. So if need be, some of these issues can be considered at the next public meeting. We explained to the presiding officer, who is the equivalent of the judge, that discussions with you and decisions had to be made in a public forum with a quorum. So that was the basis on which they gave us a 1-week extension. So there are 6 steps to this as I see it. The first is to review the issues for resolution. The presiding officer has defined 2 regulations, wetlands regulations, and he would like our arguments to adhere to one of those 2. I wanted to discuss the arguments, and the reason I'd like to discuss the arguments is to see if there is agreement. If you agree with the position we take and we're agreeing with the position that you're taking, then the decision whether or not to proceed jointly. If we decide to proceed jointly, we do need to do 3 further things. We need to develop a rebuttal to oppose the plan revisions, and we need to oppose the joint motion for a summary decision. And then I am suggesting, and these are all suggestions, that we then file a new joint motion for a summary decision. So in terms of process, those are the 6 decisions. I actually printed all of this out, and I'll distribute it to everybody in just a minute so we can review it. The 2 issues for resolution in the appeal, the first is 310 CMR 1057-1, and that's whether the proposed project is consistent with the interests of storm damage prevention and flood control. And I'll provide this definition to you. It's right out of the book. Storm damage prevention is defined in 310 CMR 10.04 as the prevention of damage caused by water from storms, including but not limited to erosion and sedimentation, damage to vegetation, property or buildings, or damage caused by flooding, waterborne debris, or waterborne ice. The second is whether the proposed project will satisfy performance standards in 310 CMR 1057-4A. For the purposes of this discussion, if I could just generalize, we're not, and maybe there are experts here that might oppose this, but we're no longer really concerned about the issue of compensation. They have proposed 6 concrete pillars. They have proposed multiples of that in compensation. They've withdrawn the Varnum Avenue site, and I think that there's very little left, and I could be wrong, but very little left to argue about whether or not additional compensation is needed or whether the compensation they have proposed is appropriate. Most of our arguments are based on the fact that and nobody knows the exact size of the trailer, 14 or 16 foot wide, 70-foot long trailer balanced on top of 6 concrete piers, unanchored, unsecured in a floodplain. That poses a danger to the neighborhood. If you have a trailer out in the middle of a baseball field and it gets blown off its foundation, it falls onto second base. If you have a trailer unsecured in the floodplain and you have a 100-year flood, not even a 100-year flood, and it's blown off of its base, you now have an ocean liner cruising through the neighborhood. You mandated that anchoring and securing take place in your order of conditions, and we believe that that is absolutely necessary in this proposal. Let me get into our 6 specific arguments, and then I'll pass this out. The first is we question the elevation of the structure. The wheels and infrastructure are part of the physical structure of the trailer. Currently, the bottom of the first floor is proposed at 6 inches above the 100-year floodplain. That puts all of the additional infrastructure below. the 100-year floodplain. And there are 27 inches of infrastructure, so it will hang down 2 feet 3 inches into the floodplain. I saw an article last week on the news. I can't use it as testimony in the hearing, but the comment was something like a car in 20 inches of water is easily moved. And I don't know how easily a trailer could be moved if 27 inches of infrastructure are in the floodplain. I disagree with Council's suggestion that there is a decreased impact to the floodplain. There is a decreased impact in compensation, but they're digging into the soil, they're posting concrete columns, and we believe that there is an impact. As far as suitability of soils, here we come to the interesting problem. The opposition has not put forward an engineer as a witness. Therefore, when we discuss engineering-based concerns, they are at an equal disadvantage to us because we also don't have an engineer. So nobody knows if the soil will support the concrete columns, particularly when the floodwaters are pushing against them. Our fourth argument and our fourth concern is the possibility of toxic materials in the soil, and particularly if the soil is disturbed or if toxic materials have seeped through the soil. The fifth goes back to the secured or unanchored trailer. We believe that trailer in the floodplain poses a greater hazard because it's in a floodplain than if we're not in a resource area. And the last is the accuracy of the plans. Because it's a public meeting, I hesitate to talk about the qualifications of those who are involved in making the plans, but if that comes up for discussion, I'd be happy to do so. Those are my comments. May I pass this out to the commission?
Just a couple questions. You're representing both the groups, the citizens and the abutters?
Yeah, and let me can I briefly explain that?
That's okay. I'm just.
And Deb Forgione also represents the abutters group.
All right, and they'll be allowed to speak too. So
she works three jobs, so I speak on behalf.
And you're suggesting a joint response with both groups?
Yes, so there would be.
So both groups are in agreement then as far as what you've just outlined?
Yes.
Okay, all right. All right, right at this point in time, I don't have any further questions. So, I mean, this is, you know, it's not necessarily a formal public hearing. It's just it's an open hearing at this point in time. So if there's individual questions from the commission, what I'd like to do is just open it up for, at least for Mr. Hamblett right now. And then what I'll do is Attorney Furlong, are you?
Yes, he's
okay. Yeah, I'm assuming you're gonna want to speak, so I don't want to make assumptions that aren't true, but I'm gonna give you equal opportunity to. I
appreciate that.
Okay.
Mr. Erickson will probably.
Yeah. Yes. And Ms. Forgione, and likewise, if you want to speak and represent your group, so okay, unless Mr. Hamblett, I mean, again, that's up to you. So okay. But this, again, is just with respect to the joint, whether or not the commission will respond jointly. So, Commissioner Varnum.
First of all, it'd help me if I could get a copy of whatever it was you had. I'm not sure I wrote this accurately, but
Yeah,
just,
if you have copies for everybody.
I've got 15, so I've got.
All right, that would be great. I think I took fairly good notes, but
Sorry.
Just looking at the arguments here, it seems that 3 of them are concerning soils. And I know we have been talking about soils since the first filing came in on this project. And I'm not quite sure why we haven't been able to resolve those questions about soils. You know, as far as I know, no test pits have been done on the site. No testing for toxic material has been done. And, you know, we're talking about now compensation, which wasn't in the original plan, as far as I recall, which requires digging into the soils. And I don't know at what point in the process this might have been introduced or whether it can be introduced now, but I think soil testing on this site is very long overdue. I don't know how you can approve something if you haven't had an engineer determine that the soils can support what is being proposed as far as sonotubes or if, you know, digging is going to be releasing toxic materials. There could have been, this is a wet site, there could have been leaching. I believe poisonous materials can travel something like 100 feet a year, I think. Or I had the figure back in my early days. And this is just not that far from the area where it's obvious there was a dump in years gone by. You know, and a dump doesn't really go away just because the paper and rotting materials are gone. There's glass left there, which I'm not concerned about, but what if this was one of the gasification sites, such as we have all over the city? We've had toxic sites right in neighborhoods next to residential homes. And there was actually toxins found the other side of Townsend Avenue and down a couple 100 feet from the same dumping episodes, which I remember from when I was young. I remember that being a dump. We could smell it a half mile away. It was always on fire. We could smell the smoke. And this is one of my major concerns right now, is these soils. The soils should be perfect agricultural soils, and I know they were used as that for many years. You know, it's a floodplain. Usually those are wonderful soils, but are they wonderful for supporting sonotubes? Is there perhaps ledge down a couple of feet? We don't know that. That would make a difference as to how the engineering proceeds, and especially the toxic materials. Even the place where the compensation is proposed has been the site of dumping over the years. There's all kinds of asphalt and who knows what else in there. And I'm not sure why this is just being passed aside. Why isn't a test, why hasn't it been done? Why isn't it proposed? Why can't we propose it? You know, it could be that the neighbors are in danger. Maybe the toxins are traveling to their properties. And certainly if you're having a 10,000 or square foot temple with thousands of people visiting, you certainly want to know what they're walking across, especially if they're in flip-flops or something else that they're going to fall out of along the way. The other, so soils is a major concern of mine. And I definitely think that it's premature to approve anything until we have more information on that issue. The unsecured trailer, after seeing pictures of flooding in the news, almost monthly, huge floods, you see, people killed and houses destroyed, and certainly water is a huge, powerful force. Why can't we secure that trailer? Why hasn't it been proposed? We asked for a secure trailer back when we issued an order of conditions, before it was appealed. And that comes back to soils too. We didn't know what you would secure it to. What are those soils? How would you need to proceed in order to secure that trailer? I think it's a hazard that's worth notifying, worth noting. The DEP says it's not a wetlands issue, but certainly it's a storm damage issue, and I don't know why the DEP has just glossed over storm damage, as they seem to have done in this proposal. That was one of the major concerns of all of us when we saw the first order of condition was storm damage. And certainly that neighborhood has proven to be a place where storm damage is very likely to occur again, and has occurred frequently in the past. So securing the trailer is definitely on my list of something that should be done. The last accuracy of the plans, I remember, I think I was the one that brought the issue of the elevations up, and we said that if anything other than what was proposed to us was proposed in the future, that we would require a peer review of the topography of this site. Now, since that time, we are now proposing compensation, which is very exact as far as the elevations that need to be compensated for. And if that isn't done correctly, then compensation has not occurred. There is no compensation if you're digging at the wrong elevation. Certainly, this is a site that demands proper compensation, and since the proposal was made to dig at the site now, which was not a part of the proposal in the first order of conditions, I would be looking for a peer review of the topography, maybe not the whole site at this point, but definitely the area of the regrade and the area of the trailer, any part of it that's going to be disturbed in this proposal. I also am curious as to what the proponents can tell me about the trailer. We know very little. Even a photograph would have eliminated some of the mystery of it. Is it going to be taken off the undercarriage? Are the wheels and the frame going to be taken away, in which case they don't need to be compensated for? Or do they remain there, such as they do when you have a mobile home park? I was just in one recently, and they make you circle in the hitch and plant flowers in there, just so it doesn't look like it's a mobile home anymore. So I think it's standard practice to leave that undercarriage on the trailer, and certainly I don't know what kind of a machine or anything else would be required to remove them. I would think that would be very difficult, and especially with an old trailer, it might cause some structural damage if you tried to remove them. So I think probably that would need to be added to the compensation. I know there's overcompensation, but I don't know how much. what is the volume of that undercarriage and wheels? And do we in fact have enough compensation to take that into account? We're very close in elevation. This is another issue that I am concerned about. We're very close in elevation to the 100-year flood line. It doesn't take much more than probably a 110-year flood, if there is such a thing, to have the trailer underwater anyway. Even if it's raised at the moment above the 100-year flood, it's possible that you could have a larger flood. And I'd certainly feel more comfortable seeing more of a safety zone there as far as raising, if you're raising it anyway, can't we raise it a little more? Not just give 6 inches of freeboard, give it a little more. As far as impact to the floodplain, I think we have to be very careful with the erosion control. I know loaming and seeding has been proposed. I don't think I've seen a cross-section of the proposed slope once they're done. I mean, I know what the elevations are, but I don't know, is that a 3-to-1 slope, a 2-to-1 slope? I don't know. And it depends on what steepness of slope, what kind of erosion control is likely to work as far as revegetating. Certainly loam and seed, if we get a heavy rain, could be washed away. And what if we get a flood while it's loamed and seeded? I would think we'd need some kind of a fiber mat or some system of that sort to be sure that we don't have that new loam just washing away in the next rainstorm or the next flood. So that's all I have to say for the moment.
Do I respond to some of those?
No, not at this time. I'm going to,
Okay.
I mean, if you have something specific that you want to respond to, sure.
We have a signed statement from the applicant that the infrastructure is part of the trailer, so I don't think it comes off, and they can confirm that. And sometime in the process, they did file a picture as a point of evidence. I believe it was in one of Mr. Erickson's testimony. Imagine the single largest mobile manufactured home trailer you've ever seen going down a highway, and that's what it looks like. It's 14 to 16 feet wide, 70 feet long. The last time we talked with the applicant, neither of them had seen it. They didn't know where it was, and the only thing we had was a picture of it. As far as the soil testing, you'll have to ask the applicant. We've been prohibited from going on to the property, and therefore we can't have any soil testing. As far as the unsecured trailer, the construction and installation of a manufactured home is controlled by HUD, and building in a floodplain is controlled by FEMA. This is in violation of both HUD and FEMA regulations. I can get the name of those regulations. But Mass DEP seems to feel that although 2 other federal regulatory agencies have said that this should not be allowed, it doesn't affect their decision, and that's beyond the realm of my understanding of the law.
Commissioner Biedron? Commissioner Gordon? Commissioner Parrish? All right. What I'd like to do, and again, we're just here to determine whether or not we want to go jointly. Actually, let me, all right. Ms. Forgione, do you have anything you want to add to the request for a joint response from your organization with the
Thank you.
commission?
Yeah. I'm not an attorney, I'm not an engineer, wetland scientist, but I just need to put this on the table. I've been here almost a year and a half. if we knew what the trailer looked like and how big it was, we would have never been here, because DOT, Department of Transportation, says that that trailer that they're proposing could never be moved at night, could never be moved on the weekend. So each and every time for a year and a half, when they stood in front of you and told you that they were going to be able to move that trailer out, that's what they told you week after week, that that trailer was going to be able to be moved. And now we find, clear as day, very easy to find online, that that trailer could have never been moved. And when you gave that approval, nobody knew that, and you didn't know that either. And I just wanted to say that that's what we've been through for a year and a half. Thank you.
All right, just stay there. Any questions?
It's 16 by 72 feet in DOT if you go online. And the reason I knew so much about this trailer is because my house is a modular home. And I remember I had a 12 by 36, 2 pieces, and what it took to get that down the street. So it never was clear how big this trailer was. And they're saying that they know that there's a trailer, they know where it is, they know how big it is, and it has never been told to this commission. And you would have known that the Department of Transportation, you cannot do it at night, you can't do it on the weekends, and you need a permit, and sometimes it can take up to 30 days to get that permit. So that each and every time they were here in front of you, and you made that decision based on the fact they told you it would be very easy to take out, and here we are 1 year and a half later to only find out that all they ever had to do was show you the trailer. And if they had given you the guidelines of moving the trailer, or if they had told you how big the trailer was, Aaron could have looked it up online. And to think that it was something so simple, but the clarity being nobody knew that it couldn't be moved. So I wanted to say we would not be here 1 year and a half later if that had ever been disclosed. You would have never given the approval. And here we are talking about putting it on pylons. And I just feel as though if we could do this jointly, because there are, even if you're not agreeing with all 6, if you only agreed with 3, we have been battered for the year and a half, coming here week after week. He came here diligently, trying to find out as much as we could, participating in this. And now they've teamed up with DEP, ignored half the things that we talked about for the year and a half. They were at the meetings. They know what you were talking about. They remember, they knew you asked about the soil. They knew you asked about the peer review. Everybody knew that, but when they're in those settlement hearings, we were never at that table. We're supposed to be equal. We're supposed to be equal at that table for the settlement, and we were never, ever at that table with DEP or the applicant. We bring a lot to the table. In fact, we were the ones that told DEP, you cannot move that trailer at night on the weekends. DEP finally said, you know something? You can't move it. That's off the table. So we had to tell them, if we told them something that important and never to ever be allowed at those settlement hearings, and here we are with their attorney sitting over there and never being able to be allowed. That's one of the reasons we wanted to do it jointly. We bring a lot to the table. We've brought a lot of information to help people make decisions. And we're only neighbors. We don't have attorneys, we don't have engineers, or we don't have wetland scientists, but we've brought a lot to the table. And one is to bring to light to you and to DEP, they could have never moved that trailer, and we know that after a year and a half.
Were the original dimensions of the trailer, were they on the original notice of intent? Did we not? I wasn't here then, so I don't.
What was the question again?
The dimensions of the trailer.
I believe we had the dimensions, were
On a plan?
aware, but we weren't aware of the requirement of a special permit and the fact that it was not as simple as pulling a tractor up to it and removing it from site. It
Okay.
required additional permits to do that in certain times of day.
Which we were told, the conservation.
Well, I'm not sure anyone was aware of that.
Okay. And the 72 by 16 was
I
on
know,
there?
I know I wasn't aware of it, and it didn't sound like anyone else was aware of it either, so.
That trailer, it kept changing. Sometimes it would be 12 feet, sometimes it was 14. I know the humor part of it. I remember being there for a year and a half. Don't you remember? Sometimes it was 12, sometimes it was 14, sometimes it was 16. It was never really pinned down, but they always knew where the trailer was. They always knew how big it was. And collectively, if you think about attorneys, engineers, wetland scientists, a former DPD, a person who was head of the whole project, they knew the requirements for taking that trailer because it's up in Maine now. They know what it is required.
Do we have the original plans that show this dimensions? I feel like it's like, I don't know if this is the original dimensions, it is what it is, but like, there's a lot of things that get snuck on here. So have they snuck on an increase in size, just like how they stuck on utilities and snuck on a compensation area?
I have the plans in the file. I don't have them with me right now, but my recollection is that the original plans had shown a dimension for the pad of the placement of where the structure would be. It didn't detail the size of the trailer.
Of the actual
And
trailer.
It had dimensions for the pad and location for it.
If I may, all the documentation relating to this case from July 31st, 2010 is in that white box. If you need anything, just let us know.
Would, to me, I'm sorry. To me, what I felt that this commission had done as part of the original order of conditions that was appealed was that we required that it be anchored to the site, and obviously that was a year ago, and now we're here and whatnot. But now I'm getting a sense, at least, that what's being proposed is to elevate the trailer, or at least there's a direction, elevate the trailer above the floodplain. Would it be satisfactory to your group if there was some sort of consensus that in addition to just elevating it on the sonotubes, that it also be anchored, such that you know, I believe Mr. Hamblett had mentioned at one point in time, you know, wave action, wind action, whatever, you know, to the extent that were the trailer to be knocked off its piers, so to speak, that its lateral movement would be further restricted. You know, it'd be like a boat on an anchor, so to speak, at that point in time.
Well, considering that the commission is supposed to help with storm damage,
That's what I'm getting at.
yeah, putting something on pylons, and when you're saying anchoring it, if it falls over and it starts to drift towards Townsend Avenue or drifts towards my neighbor Eileen's house, and everyone sees that it's coming, nobody can come in and get it.
Well, I'm thinking putting it on, you know, and I don't want to make light of this situation, but a very short leash. And I don't think that would be a very difficult, you know, and again, I'll let the applicant speak, but I don't think, to me at least, that that's a very difficult thing to do, considering that was discussed as part of the original order of condition. I think it was part of our order, that it be anchored, you know, to some moorings or some posts that were, you know, driven in around it, such that it prevented lateral movement.
But you have brought up a few times, okay, so say, this is a different plan than we were coming for a year and a half.
Yeah, I agree.
I have neighbors who, as much as we're engaged, it would be news to them that you're gonna put a trailer on pylons in an area that you know that needs to be soil tested. It's different. Everything that we've talked about is different. It is no longer on wheels. It is no longer can be moved out. Now it's on pylons. There was supposed to be a peer review for taking the compensation. There's just no aspect of it that is the same other than it's a trailer from a year and a half ago.
All right, I guess what I'm trying to get at, or at least answer in my own mind, is, and again, this is whether or not the commission joins, with two citizen groups in their response, whether we have a consensus that our response, and again, even if the commission doesn't file a joint response, so to speak, doesn't mean we're in disagreement. It just means that the commission may choose to file its own response.
We have been coming here, I'd say it was almost 2 years.
Oh,
And we add
I've
a
been
lot
here,
to this.
I think I've been here every meeting, and
Okay. And we have been bringing so much to the table.
I
So many
agree.
things that have been discussed to make this, when you gave them the orders of condition, we did disagree with it. And here we are because we were right. There were parts of that weren't correct, and we were right. So when you're saying there are parts of this that should be denied that we would all agree on, if we knew which ones those were, we could probably define which ones we all can agree on. And from there, I would have to discuss with everybody, but I would suspect that there are parts of this plan that can't be disputed.
see, but that's, I suppose, where you and I may disagree. I feel, and I felt back when I voted for the original project, that it was possible for a trailer to be placed on the site and to prevent storm damage prevention. Now, at that time, we didn't know that the movement of the trailer had some rather significant and severe restrictions to it. Had I had known that back then, I would not have voted in favor of what we approved. I will agree with you there. And through the process, it has come to light that special permits are required to move this trailer. But I still feel that, regardless of that the trailer can be placed on site and also meet the performance standards of the Wetlands Protection Act. Whether or not, and again, this is something the commission will get into a little bit later tonight, whether or not what the DEP and the applicant are jointly proposing to the hearing officer as part of a settlement, I'm not sure I agree with. But I also, my position is I think it can be done, but whether or not I agree with what the applicant and the DEP are proposing, I would say no, not at this time. Okay, I still think it needs more work, and that to me is what I think the commission, may make a part. Well, I don't know. I mean, obviously we have to take a vote on it and reach a consensus on our own. But at least for me, I think that it can be done, and that there's a method to do it, a relatively simple method. But Ms. Varnum outlined some concerns. Your contemporary, Mr. Hamblett, outlined some concerns. I agree with some of them. I disagree with some of them.
We did point out, again, we bring a lot to the table because the neighbors brought up the fact that there was a dump there. So again,
See, this is why we have these public hearings. They work. And
Yeah,
we
they do.
appreciate, because I agree, you folks have brought stuff to the table that normally this commission is not privy to. And, our eyes and ears are you folks. And and you guys are making it work, and we have far too many projects. You know, I can wax philosophical all night, but we have far too many projects where there's just no interest at all. And, you know, there may be things that this commission just never, you know, has information from people that have lived there for, you know, 10, 20, 30, 40, 50, 60 years, that have, you know, particular information that you folks have brought to the table.
Well, I
in
think
this
that's why, as the
particular instance.
abutters, we thought that it needed to be under a new notice of intent and properly notify the abutters, because there were some houses that were missed originally when they sent them out. It's a whole new proposition. It can't be moved. They want it to be there for 3 years. They want it on pylons. There are just so many aspects of it that I think that need to be discussed
Well,
as
if-
they come forward.
Well, I don't want to keep going back and forth. If there's any further questions from the Commissioner, Ms. Forgione, okay. All right, thank you.
Thanks.
Attorney Furlong, if you'd like to.
Thank you, Mr. Chairman, members of the board. My name is Michael Furlong, and I represent the community of Khmer Buddhist monks. We appreciate your time tonight. We're here because we just want to make sure, in deference to the commission, we want to make sure that we can address your questions. This has been a long process. We understand the abutters' concerns. We've tried to address them. We've spent 2 days in settlement discussions with the abutters, and we've really tried to address everything. The trailer is in Maine. That created some of these questions as far as the size. It's a 70 by 14-foot trailer. We weren't sneaking things onto the plans. There's a gentleman who did the plans, and then we have Steve Erickson, and if there was anything, it was a disconnect. But we kept going back and correcting the plans, and we've been responsive to DEP and the abutters as best we can. There's situations where you're not going to appease everyone. I think this is that situation, but I think we have to make it. I just want to be abundantly clear that the petitioner here is trying to do the right thing within its means. We're not trying to do anything untoward or trying to sneak anything by anyone. DEP wasn't on our side originally. After 2 days of just trying to figure all this out and addressing concerns as they came up and addressing the board's concerns that came up in July, we got to a position where DEP agreed that this project was appropriate given raising it out of the floodplains. The issue about moving, first of all, we're not going to do anything that puts anybody in harm's way. This trailer, it will be anchored. We will do that. It will be secured to the sonar tubes, and I'll let Steve Erickson address those specifics, and you can ask him those questions. And that's why we're here tonight. We don't want this to there's been a disconnect going forward. The abutters have done an admirable job of raising issues, and that's their right. We've tried to address those issues. Movement of the trailer did become an issue. We didn't foresee that. We actually believe that we could travel. If you look at the map, we thought we were on city roads in the initial plan, but there were sections that were technically state roads. And it's not clear with DOT as to whether or not, well, I called DOT and I told them what our situation was, and I was told that in an emergency situation, you can move the trailer and then you can get a retroactive permit. But it's not, it just became too complicated. And DEP went through this. We just agreed that the best thing to do is to move it out of the floodplain. So that's what we did. We weren't trying to do any end arounds as far as this thing went. It just became clear through issues raised by the abutters that we couldn't transport it through the city. And so raising it out of the floodplain that's a better safety solution for the abutters. As far as This is an 11-acre site. We believe that we can, you know, we can get this thing done. We're going to be, this is the most important point that I want to make. We're going to be in front of this board for the foreseeable future. And we need to work with the board, and we need to make sure that the board recognizes that we're willing to work with them. But right now, we're in a very sort of narrow procedural position in this case, where we've addressed the issues that DEP has raised, and we're now set. There's a motion for a summary decision in this case, and you know, I think that the evidence is there that it's appropriate that the decision, based on those narrow facts that are before DEP right now, gets resolved. That's where we're at. But tonight, we want to just address the board's concerns, because we don't want to give the appearance, if the board thinks that we're trying to do any kind of end around here, we're not, and that's why Mr. Erickson's here to answer your specific concerns of how things might have not been on the plan. It was disconnects, and I'll admit it hasn't been the smoothest process for us, but we've addressed over the last 6 months as much as we can reasonably of everyone's concerns. So I'll let Steve Erickson discuss some of the specifics, if you have any, as far as some of the issues that have been raised by the abutters. Any questions for me?
No, I made a comment at one of our more recent prior hearings on this, and I understand that. I think it was our last meeting or the one before that was rather sparsely attended by interested parties on this, and that perhaps may have been just a matter of people not seeing it in the paper, vacations, whatnot, but that does happen. But I feel that with the folks that were for the applicant, that were at some of the earlier and earliest hearings on this matter, and my recollection was that the size of the trailer doesn't surprise me, because my recollection was that it was always in my mind that this was a 70 by 14-foot trailer. I know there was a characterization that it's 12 or 10, but I always felt that it was one of these large, that with the, if it's on the highway, they've got a car in front of it and one behind it with flashing lights and stuff like that. What I was unaware of, though, was the fact that it required special permits just to move it. We had spent quite a bit of time, perhaps even several meetings, about moving this, and it was suggested at one point in time, why don't we just raise it above the floodplain and well, neither here nor there, but there were people here for the applicant that should have known that this type of trailer required special permits. They were in the construction trades, they were in the, the DPD. One was the former head of the DPD for the city of Lowell for a long time. So I was a little chagrined that these folks didn't know that a trailer of this size was not, or was just a matter of pulling a tractor up to it and moving it off-site. And thus my comments that I felt we had the wool pulled over our eyes. I really do feel that way. And what I've heard tonight doesn't change that.
If I could just comment on that. If we thought we could move the trailer within the city of Lowell, if we move, DOT only applies to state highways, so the special permit issue only applies to state highways. The problem so if we use the Demoulas property, which we tried to do, we wouldn't be on state highways, we wouldn't need a permit. At Mr. Walsh I spoke to, and we also tried to use, I'll slaughter the name, but Kajonian's property. We had an agreement with them, but it wasn't until the last couple months that we realized that there were just small sections that were considered state highways. So conceivably, if we could have gotten an agreement with Demoulas, which would have been perfect for us, we wouldn't have needed that. And Mr. Walsh was somebody that I was speaking to and didn't indicate to me that there was any need for a special permit. So we didn't have any idea until that issue was raised and we researched it. So I apologize. I understand that there are block sections that required us to get a permit from DOT. We tried to work around that but we weren't successful. That's when it became apparent that raising it up made the most sense. So I apologize. I don't think anybody understood that. Certainly Mr. Walsh didn't, because I spoke to him within the last 6 months, and he indicated to me that, and I don't think we had the right connection there, because he's, his position was that happened frequently. Things were moved but I don't think that he understood that there was a section of the boulevard that was considered state highway, which...
So what you're saying then is that these permits are only required in instances where the vehicle is on a state highway as opposed to just a residential or City of Lowell streets?
City of Lowell, DOT. So it's, you can go to the DOT site and it'll show you. But that was my understanding from researching it when the issue came up. Conceivably, we could have done that, and that would have been the easy solution, but we couldn't get an agreement with Demoulas, which would have been, it just would have made everything a lot simpler.
Now, I would suppose that anyone with a CDL would or should have been aware of that situation, though. I mean, the average person out there driving under a Class 3 driver's license doesn't know if they're driving on a state road or a local road or whatnot, or whether, and just presumes that the laws of the road are the laws of the road, and they're the same regardless of whether you're on Townsend Ave or on the boulevard.
Right.
But I would imagine that someone in possession of a CDL not only would know that, but they would have to know that.
Right. Unfortunately, the consultants we were using didn't realize that, but again, I did have that conversation with DOT. It becomes irrelevant at this point because we're not going to do that, because it just wasn't going to work. But it was kind of, when somebody tells you they have an unwritten policy that you can move the trailer in an emergency and get a retroactive approval or permit, and you can always get a permit, what I'm told. Again, this isn't, to some extent, this isn't credible evidence because it's just a conversation I had, but I was told by the representative who handled these things from DOT that you get a permit within 24 hours, and if it's a problem, you just call this number, leave a message, and you can get it the next day. That doesn't satisfy what we need. We can't move forward with that plan. It's just not formal enough. So it just made it for a very convoluted process that wasn't in the interest of the neighbors as far as safety goes, and the far better solution was to move the trailer up.
Now, I know that, well, I don't know, but I know that you were not a part of the earlier hearing process. I don't know when your representation was brought on. That's neither here nor there really, but the raising of the trailer above the floodplain was probably the subject of at least one, maybe two meetings of this commission, and putting it on sonotubes basically, and taking the trailer out of the floodplain and anchoring it and providing compensation. I believe the old ancient road that leads from Varnum back to the cemetery was discussed as a compensation area, or even was suggested as a compensation, but the applicant rather forcefully chose not to go that route at that time. The reason I bring that up is because we're kind of full circle now. We're back there. Okay, and again, it's something that I was amenable to a year ago. The problem that I have with it now is that had we gone that direction back then, I would have, at least to satisfy my own obligation for storm damage prevention, my own obligation as, as a commissioner for the city of Lowell and under the Wetlands Protection Act, would have requested a peer review with respect to the elevations and with respect to the soil suitability for, supporting the weight and anchoring the weight of that trailer. Likewise, for any cuts and fills that were going to be made, to review that data. But we didn't go that route. We went something else that involved no disturbance to the site at all, other than just the gravel area under the trailer and a simple access way into the trailer. So now the proposal for the summary disposition is to do something that, had it been part of the original order, we would have had some additional information. Whether or not the information that we have now is accurate or not, I don't know. What I can say, though, is some of the elevations on the plan that was prepared by Mr. Close, there's some observable errors in it. We don't have an expert to say now. There was no peer review process with respect to the elevations to say that, in fact, they are erroneous. But, collectively here, we've got two members that have been on this board in excess of 15 years. I don't know about Commissioner Varnum, but I've been reading plans like this in excess, of 20 years in my practice and as a commission member. And, am I an expert? Not by definition of the law, but I can read a plan. And I know what I'm looking at is not represented in the field. And there was some observable differences that were readily apparent to, I'll call myself, the lay eye, so to speak. So now, had we gone the route of cut and fills and providing flood compensation, I would have been satisfied with a peer review as to whether or not the elevations on the plan were in fact accurate, and we would have gone that process. But now we're basically foreclosed from that now, because it's too late and we're not part of that particular process, and we cannot at this point in time, with respect to this particular issue, request that. That's my primary concern now about the process going forward and what's been proposed, is that duty bound to the city and duty bound to make sure that, well, now it's not this commission's responsibility anymore to make sure. It's the hearing officer now, and we're just a party. But I feel that this commission should propose, or should at least object to, the cut and fills as being proposed as being accurate, because of observable differences on the plan and in the field.
I could respond.
Yeah, absolutely.
As far as the trailer issue goes, we're not in complete agreement with DEP. Our position was, I'm sorry, I got a cold, I might sneeze here. Everybody wait. Excuse me. Our position was that we didn't need compensatory storage, and I'm just paraphrasing Mr. Erickson's thoughts. The plan, and I got involved during the appeals process in this case, but Mr. Erickson believed that the trailer was going to be pulled out before there was a significant flood event, and therefore we would need compensatory storage. DEP didn't agree with that. And in their papers that they submitted in this appellate process, we still don't agree, but we agreed to just rectify the situation. We thought if the trailer's not there, then we didn't need compensatory storage. DEP's position was that the regulations don't make any distinction between a temporary or permanent structure. Therefore, we needed compensatory storage if that trailer was there, and even if we planned to remove it during a significant flood event. So that's why you didn't see compensatory storage initially. We didn't believe we needed it. We told DEP, and that was subject to our initial kind of pushing back negotiations with them, was when we thought we could remove this trailer, and we thought at times that we could, with DEP, that we could get a plan that worked removing the trailer, and we, just different iterations, it went round and round, and then it just became apparent the trailer's not moving, now we have to do compensatory storage. That's how that happened. We didn't initially, and quite honestly, through most of the negotiations with DEP, think that we needed to do compensatory storage. But it's an 11-acre site, and we can do compensatory storage, and we're doing 10 times the required compensatory storage. That's how that happened. It wasn't that we were trying to circumvent peer review of any nature. It got there through this not perfect negotiations in trying to resolve this case. Again, this is a long-term relationship with Lowell Conservation, and this is just the embryonic state of this thing if we're to move forward. We're trying to address those things, and that's why I'm glad we're here, that we can explain how imperfect this is and how we got to this, where we are today. But I think the most important thing, again, is that we're trying to address these things, and with a number of different parties, and we're never going to please everyone here. We're just trying to do as best we can given the situation.
No, I understand what you're saying, and I understand the proposal is, substantial cuts compared to the fill introduced by the sonotubes. I understand that. My issue, though, is if the cuts aren't at the correct elevations, then there's no point to them. Or they, in fact, they may be taking credit for cuts at elevations that don't meet the fills at elevations. After all, as you know, the Wetlands Protection Act requires that for every foot of fill at a certain elevation, you have to remove a foot at the same elevation. And if the elevations, and again, this goes back to my point, that there was some readily observable elevations that were plainly wrong on the plan. If the elevations as indicated on the plan aren't correct, and I know Mr. Erickson can come, but Mr. Erickson isn't a civil engineer. He's not an expert on elevations. He's a soil scientist and a wetland scientist. But if the elevations aren't correct, then we don't know whether or not we're getting 10 times or 0.75 times. Okay. For a site like this, and again, this is a site that's a good number of feet below the 100-year floodplain. There's a very, very limited opportunity to make compensation on this site. And if the elevations aren't correct, if the area that we're claiming for compensation is too low, or if it's too high, if it's too low, we're just digging a hole. And you can't do that under the Wetlands Protection Act. And if it's too high, then we're not providing compensation at the proper elevations and at the critical lower elevations.
Right. I'd have to defer to Mr. Erickson to discuss that. I'm certainly not an expert reading maps. I know that DEP had us go back as part of the revisions and look at those and give them more information. But I think Steve would be better to address that. But it was a concern of DEP, and if there's an opposition filed, I'm sure that
Well, that goes back to my point, is that we can't do that anymore. we've lost the ability to do that in this process, and that's my primary objection. And I'm just stating that's why, and I know that the PCC and the abutters feel that that's a non-issue at this point in time, but I still feel it's a rather important issue.
Right. Well, I'm going to let Mr. Erickson speak, but as far as, I suppose, if that your decision to move forward jointly or separately is
Well, again,
whatever.
it's, as I said, it's not up to us anymore, it's up to the settlement officer, so it's up to the hearings officer,
Right.
so.
But again, it's just, it's important that we address what we can and explain how this was an imperfect process. But I think we've met our burden as far as what we needed to do with DEP in resolving this matter. We're going to be here for a long period of time, so we're not trying to do anything other than what we're able to do.
And, through you to Mr. Erickson, I guess, and perhaps he can answer it, is it a possibility? Is it something that can be easily accomplished? Is it something that can be addressed? And that's anchoring the trailer to the sonotubes.
I believe he will tell you that he plans to do that, and I'll let him speak now. My final point is we tried to address all the board's concerns in their July letter to DEP, and we'll continue to try to address concerns that we can do. So.
Lastly, what I'd like to say is I appreciate the fact that some of our original concerns were addressed and there were some modifications made. I do appreciate that. But again, it doesn't foreclose and it doesn't change the fact that I'm still at odds with that, we're now considering a cut and fill situation, whereas that was never contemplated as part of the original order. And I think that this commission has lost some, again, the characterization is that this is a non-significant change because, one, I guess because it's a relatively minor cut and fill, but two, there's, overwhelming cuts being provided for. But again, it goes back to the original thing is, are we at the right elevations?
Right. I'll let Mr. Erickson speak. Thank you very much.
Thank you.
I actually had another comment I wanted to make.
Yeah, just a second, Attorney Furlong.
Based off one of the comments you had made, as well as in the rebuttal documents here regarding the Mass DOT travel permits,
Yeah.
you had stated as well in here that it basically says that as of your understanding or as of conversations you had, that they were not needed. But I think it would be useful for us to know what the actual state of
Right.
the permits are.
You can go to Mass DOT, the website, and that's what I did. But I could get that for you as well if you want. I'm sure.
Hold on, the discussion is, the floor is with Mr. Attorney Furlong.
I can get it for you. It's on the website. But the problem that we had was the informal discussion with the representative who issued those permits, that he would do it retroactive. That's not.
If you could furnish it to our office, that would be appreciated.
Yep.
Thank you.
I'll get it to Mr.
Is that-
Claus.
Yes, that's
All right, and I'm sorry, I foreclosed Commissioner Parrish. All right, Commissioner Varnum, any questions?
I just am still curious about the undercarriage, why that wasn't, why the volume of that wasn't in part of the compensation figures.
The undercarriage.
Even if the cuts are 10 times the proposed fill, however, we don't know, that maybe they're only 2 times the fill now. We don't know, and we don't know what elevation that is at, that undercarriage.
Well, I think that Mr. Erickson could do a better job answering that.
Commissioner Biedron? Okay. Any further questions, Commissioner Gordon? No? Okay.
Thank you very much.
All right, thank you.
Good evening, Stephen Erickson from North Environmental Services. I think I've only got a couple of points to make. One is that when we first started this process, we had told the commission that the reason we were leaving it on wheels was so we wouldn't have to compensate, so we could move it out of the floodplain. It was at that time, in the very beginning of the process, that we told the commission, if you want us to lift it up out of the floodplain, we could do that. And the commission seemed to agree at the time that it made more sense to leave it on wheels and move it. But I'm not a truck driver. I don't know the rules of trucking. So that was an error on our part, not knowing that we needed that permit to get it out. As to anchoring the trailer, the building code requires that whether it's a house, a trailer, or anything else, that it be anchored. The conventional method of anchoring a house is when you have the poured foundation, you have a 6-inch bolt that goes into the concrete. 3 to 4 inches of the bolt is out the concrete. We put down a 2x8, 2x10, and you bolt it down tightly. That's exactly the way that this will be done, except we won't be using wood, we would be using an I-beam. And that would be checked by the building inspector. The building inspector would likely require a structural engineer to come up with a specific design for that. That's what I would expect. But the building code requires that it be anchored. There's no way around it. It will be anchored. Nobody would just put a slab on a post without protection.
All right, can we just stick with that for a second?
Sure.
All right, and I noticed, what's our base elevation now that's being proposed? You're at 101.25 feet now?
Yes.
For the,
Now, the top of the sonotube would be at 100.25 or above. There would be I-beams placed on that. That would likely lift it 6, 8 inches above, depending on the thickness of the I-beams. The trailer would then be on top of the I-beams.
see, I believe that the comment was, and to me, no, and I don't know, see, and this, I guess, is where I additionally have difficulties here. And it's still an open and unanswered question for me. And it's one of the points that you know, again, I'm in disagreement with well, in any event, Mr. Hamblett had mentioned several meetings ago about, in the event that, you know, you have a wave action or whatnot, you know, wind action, wave action, and the trailer itself is ripped from its anchor. You know, as we all know, you know, something that size, I mean, that's a big vessel.
Since the trailer is going to be raised at a higher elevation than almost every house in the neighborhood, every house in the neighborhood would be washed away prior to the trailer being washed away.
But as you know, Mr. Erickson, that's not how it works. It's usually the foundation itself that floats, provided that it doesn't have any cracks in it.
No, the
It's usually the
foundation doesn't float.
groundwater floats the foundation.
No, that is not the case.
Well, that's generally what happens in high floodwater situations.
Usually in the high flood water, there are windows that cave in and the foundations fill up, and if the buildings aren't properly attached.
Provided that the water pressure equalizes on both sides of the foundation.
If you look around that neighborhood, you will see that almost every house in that neighborhood will be flooded long before the trailer would be flooded.
Yes, I understand that, but we're not talking about every house. We're talking about one specific piece of equipment, and that's essentially a boat.
That will be lifted out of the floodplain.
Okay,
It will be less than a 1% chance of a flood event.
all right. What I'm still in disagreement with, and I'm somewhat still in agreement with the opposition here, is that in the event that this is ripped from its piers, what happens to it then? It becomes a boat. It blocks roadways, it destroys houses, it starts floating. And as we all know, floods don't happen in isolation. They're usually attendant to hurricanes, high winds, and other unsavory weather incidents. And things move laterally as well as vertically. and those types of situations. It's all part of storm damage prevention. If I can think about it, it's probably going to happen. You know, and I don't think I'm being unreasonable here. You know, I think it's foreseeable, to put it into, you know, legal terms, that something like this could happen. And it's something I feel that can be very easily corrected. And thus my comment about keeping it on a short leash. If you put a cable around an eye bolt on it, it's not going to go anywhere once it's floating. All right? It's a clothesline will hold a relatively large boat in place once it's floating. You know, it doesn't really take all that much at that point in time. You know, I believe that's something that we had discussed and addressed and was part of an original order.
That's absolutely something that we agreed to in the original
Yeah.
order. And I don't have a problem with that either. But the building code addresses the anchoring, and it will be
No, I
anchored.
understand that it will be also anchored. And again, I don't have a problem with that. It should be anchored. But what I'm saying is, in the event that the anchoring fails, then what? And that's what I think is a big concern here.
If you want belts and suspenders and some other means of holding it down, we don't have a problem with that.
All
We've
right.
agreed to that from the very beginning.
All right.
It hasn't, you have no argument with us. We don't want it to float away anyway either. So we'll suggest it to DEP as part of the agreement. We'll do it.
Okay.
It's not a substantial cost.
All right. I still have, and again, I'm in agreement with Commissioner Varnum that, you know, and again, this is something that was raised as a part of the original hearing process, the suitability of the soils to support, you know, the piers, or in this particular case, the sonotubes. You know, and again, we can bolt the sonotubes to the frame, to the I-beams, to the trailer, but what's keeping the sonotubes in the ground?
Mr. Zachara, I got 41 years studying soil, along with my other certifications and degrees. I am a soil scientist, and I've been studying it for 41 years. I can tell you right now that all of that soil is sand. The sonotubes are going to be sitting on a footing, just a conventional footing that would be poured, and then sonotubes will be attached to that. The type of material that's there is almost perfect. The only thing better than sand is gravel. And you don't see foundations all over the neighborhood that are twisted in locations, off locations. This is an outwash deposit. It's a great soil to work with.
So it's your professional opinion then that in the event that a flood were to happen, such that it got to the point where this trailer was to be a floating vessel, or there was water at the base of it, that the sonotubes would hold in the ground? as they're being
Subsidence of
proposed?
this soil is not an issue. It's not the type of soil that would have that problem. If it was soil that was high in clay, if it was on the side of a hill, then that would be an issue.
It's a simple yes or no question,
It's not
or
an
an
issue.
answer.
The answer is yes, it would be fine.
Have you done a boring? Have you done a boring or any?
I have done augering, which is shallow borings, 2 feet to 3 feet down by hand, to look at the type of the soil.
So how deep did you
We've also
go?
done some excavation when we took some of the boulders out. But the way you know the type of the soil in this area, besides looking at the Natural Resource Conservation Service mapping of the soil, is by looking at the geology of the area and the topography of the area. You can do the mapping by looking at that stuff. I can know the type of soil that's there, and I can verify that with a shallow hole just to verify that that is the type of material that I'm getting. I have taken numbers of courses on soil mapping. I have mapped soils for years.
How deep did you go? When you
18 to 24 inches,
And how deep are the tubes gonna go?
4 feet down.
So that,
The the footing has to be at least 4 feet to be below the frost grade.
so you didn't go though as deep as the tubes?
I
are
did
gonna
not go 4 feet in the ground, no.
All right, lastly, my last concern, because it's been raised several times, is whether or not we have toxic soils out there, and my own opinion of that, and I know I'm probably in disagreement with some of the members of the commission, is that's really, I don't feel that this particular project and our particular response is, I shouldn't say super critical on that issue, but I'm of the opinion that the type of activity that we're dealing with here is relatively minor with respect to the disturbance and the toxicity or the potential toxicity of the soils on the site. I think that I would be more of the or more leaning towards satisfying that issue in the event that a project were to go forward in the future on this site that would contemplate more significant disturbances of the site as opposed to the relatively minor disturbances as being proposed now. The trailer disturbance was always contemplated as part of the original order that was appealed. The only difference now is that there's a small compensation area being performed, and my own observations were that the compensation area was somewhat removed from the areas that I observed to be readily available, but again, that's just surface soils, whether or not there's anything underneath or whatnot, but the compensation area as described is relatively minor and small, and I would anticipate being sealed. So again, that's, to me at least, doesn't seem to be a pressing issue or one that I would want to go or make a part of any response by the commission. But again, that's just my own thoughts on that at this time. And those are my own thoughts completely. Commissioner Barnum? And again, this is questions for Mr. Erickson, and we're kind of going to just segue into our own answers to the thing, but if we have questions specifically of Mr. Erickson.
Well, I guess the question, not necessarily for Mr. Erickson, is I don't know what our rights are as far as requesting anything. As you say, we're pretty much past that point that we have that kind of input. Is
Well,
that correct?
well, no, as far as our response with respect to the summary motion or the summary disposition should be to state our concerns, and ultimately it's up to the hearing officer to give proper weight to either the applicant and the DEP's position, to the PCC's position, to the citizen, to the abutters position, or to the Conservation Commission's position. They can adopt. They can modify, the officer can adopt, modify, and they can choose to, or he or she could choose to go in a completely different direction. I mean, they're not, correct me if I'm wrong, Attorney Furlong, but they're not bound by anything that's proposed. Unless the settlement is agreed to and is, otherwise meets the performance standards of the Wetlands Protection Act, then they would be duty-bound to accept the settlement. But since there's no consensus as far as from the various parties, the hearing officer would be allowed to put together his own decision.
It's like summary judgment, that he's going to look at the two issues that are on the table, whether or not this plan is consistent with storm damage prevention and flood control, and whether it satisfies the performance standards. Those are the two issues that he's going to address, and he's going to look at it just those narrow issues.
Right. So whatever he chooses to adopt or whatever is proposed, as I said, he has to lay it alongside the Wetlands Protection Act, and provided it meets the standards, he can choose to adopt it or or
Right.
not,
Right.
so.
But it's very narrow on those two issues, so that's what he's focused on.
So, again, we can advocate our position and make our position known but what I'm saying is well, anyway, go ahead, Commissioner Martin.
Excuse me. Well, it seems that all parties are agreed as far as the anchoring, but that's not yet in the settlement. So I would hope that that would be, if we say that's a concern of ours, that would be something that the officer would change about the settlement agreement. The anchoring and the, I guess you'd call it tethering, the other
Well,
part of it.
we would agree on that, so we're going to have an agreement. We'll do that.
But I think it needs to be written down in the order of conditions. They're proposing a final order of conditions, and that particular part is not in there.
Right. I'm sure that we can let DEP know that that's just an added safety feature. They're not going to, no one's going to push back on that, so
Yeah.
I don't see that being a problem.
You guys state that still in the drawing, that the trailer bottom is elevation 101.25, but now you're saying there's an I-beam with a bolt,
Above that.
so the I-beam,
I
you're
believe
saying now that the
Well-
top of the sonotubes are gonna be 101.25.
I'll let Mr. Erickson give you the right answer.
We have the sonotube set at an elevation, a minimum elevation of 100.25.
Okay,
That's the
but this
floodplain
plan says the
elevation.
trailer bottom.
The trailer bottom has to be set on something. It can't just span the distances. It's got to have some kind of support.
No, I
envision it-
agree, so, but what I'm saying is this plan doesn't say an I-beam, and you said the I-beam would add another 6 inches to this, so I think you should be adding 6 inches to your trailer bottom elevation 101.25, because now you have a 6-inch I-beam in there.
Minimum elevation, all right? But it's like when you're building a house. When you put the foundation in, you have to have layers of wood to rest the foundation on. You can't just rest the foundation floor right on the wood.
I know, and you're
provide
choosing
supports.
to use an I-beam, so what I'm saying is, and to go on with Commissioner Barnum says, there are some changes on here that need to be addressed in the order of conditions and on this plan. An I-beam, a bolt,
I don't see the structural issues as being an issue for the Conservation Commission, though it is, of course, an issue for the building department. And I would expect that they would want to see some well-designed plans by a structural engineer to see how it is constructed, but it has not got an issue with the Wetland Protection Act.
I just think we should have the anchor included.
Yeah, well, I think this commission, as part of our response, can say that, we'd want to see the floor of,
The anchor and the bolt, that's
well,
what he's
the
calling the
floor-
anchor,
the
is that
floor-
one little bolt, so I want to see the bolt.
yeah, the floor of the trailer to be no lower than a certain elevation. As I said, there's 2 elevations on the plan. One is 101 and one is 100 feet, and I'm gonna go with the 101 because that's the higher elevation. So, again, it's the floor of the trailer, once you're out of the floodplain, it doesn't matter whether you're 20 feet out of the floodplain or 6 inches out of the floodplain, you're out of the floodplain. But,
No, I just don't, right now the plan says the trailer bottom is at elevation 101.25. I want the trailer bottom to be an additional 6 inches, because I don't want the I-beam in the floodplain.
oh, I see what you're saying, yeah.
I don't think the DEP wouldn't allow the I-beam to be in the floodplain.
I'm just saying that's just what the plan says, so maybe you want to say bottom of I-beam or top of sonotubes is at 101.25. And that does affect us. Sorry,
I think
Commissioner
that's
Barnum.
an important point.
Yeah,
but,
and we can make that as a part of our response, whether or not, they.
And having that I-beam actually raises the floor of the trailer probably another 6 inches, which was something that I was proposing
Right.
earlier.
I'm not going to tell the board what to do, but if you submit your opposition, we would respond to it. and your concerns, a new round of concerns, then we would focus on those concerns and attempt to address
So if I can just, the sonotube is 100.25?
101, 101.25, is that what I'm
I'd like to
understanding?
get those figures so we get them right. The top of the sonotube is what?
The top of the
101.25.
sonotube has to be 100.25 or
Okay.
above.
So the,
That's the floodplain elevation.
so the I-beam, would it be at
The I-beam would be
at
above that.
100.75, say, or,
I don't know what size I-beam. I don't know if it would be a 6-inch, 8-inch, 12-inch. It's a structural detail that I'm not qualified to provide.
we'll call it 101, and then we would say the bottom of the trailer would be above 101, at 101 or above.
I don't know what the bottom of the trailer, what that's held up. I don't know structurally how the trailer is built.
Well, there is a figure in here, I just
The figure
can't
is a
find it in
minimum
the 44
elevation
pages right now.
The figure is a minimum elevation as required under the Wetland Protection Act, under the performance standards for land subject to flooding, that we're above the 100-year floodplain.
There was a specific figure mentioned in this settlement agreement, I just can't find it in the 44
If I
pages.
may,
Raised it 3 inches?
if I may,
Yeah.
Commissioner Varnum, I
Yeah.
can address that. In the settlement agreement, it states that the flood elevation, the base flood elevation was stated in the plan in this settlement agreement at 100.25 feet, and that the base elevation of the structure, the trailer structure, would be placed 1 foot above that, so that'd be 101.25 feet.
101.25?
Yeah, so, good, then that meets your suggestion.
Thank you, Aaron.
If I just might circle back around to Commissioner Biedron's concern, though, your concern was that the plans themselves state that the base of the trailer is at 101.25, and you're asking what elevation is the top of the sonotube, correct?
Correct.
So maybe
And I
that should
mean,
be
you
part of the
said,
response.
you said there was a 6-inch, and then you just backed up and said you don't know what it is, 6-inch. I just don't want it to be a 1.5-foot I-beam, and then now we're in the floodplain.
No, it starts above the I-beam starts above the floodplain.
We would expect the sonotube to be at least at the top of the floodplain elevation.
Okay.
Whatever structural members are placed on that would be lifting it up. And I'd be guessing to come up with a number, but if you want it 1 foot above, once we're above, we don't care if it's 1 foot or 2 feet. It doesn't really matter to us. You could say you want it 3 feet above, and we wouldn't necessarily disagree with that. But the point is that it's got to be at least at 100.25 to comply with the provisions of the Wetland Protection Act regulations.
So the
That's
top
what
of
it
the
does.
sonotubes is at the floodplain elevation.
They would be at or above the floodplain elevation.
I think what we're getting at is that the commission would like to see the top of the sonotube to be above the 100-year floodplain. I feel the same way. And then, regardless of your I-beam height, 6, 4, 10, 12,
That would
24,
be
it doesn't
fine.
matter at that point in time because the substructure is above the floodplain.
If that's an issue to the commission, I would
Yeah,
recommend
I
that you
mean, that-
suggest
it is,
because
I know it is for me, and I'm getting a sense that it is for the rest of us, too.
Yeah.
Yep, it's still your,
Well, my other concern was the soils, and I certainly respect that you've been looking at soils and digging around for 40 years, but we need something in writing, I think, and normally when people come to this board, they've done test pits, and then they can tell at what point the soils change from one form to another, and where the water table is, and whether, if you've only gone down 1.5 feet, you might hit rock, and that might change your engineering as to how you're gonna proceed with all of this. So
Normally-
I don't know why,
normally test pits are not required for a single-family home, and people usually don't do them unless there's a particular reason to suspect a problem with it, like a high water table. Though I have done hundreds of test holes for single-family homes because I'm also a registered sanitarian and a designer of septic systems in New Hampshire. I don't have a problem doing test holes if somebody wants test holes. It's one of my favorite things, looking at holes in the ground.
Well, I mean, I don't think it's unreasonable to expect that you're going to need to be doing them at some point for future progression of the project.
Absolutely.
So
In a different location, but
I
we'll be
think
doing them.
this particular part of the project is just as important as the next step.
If the
that,
commission and DEP and the adjudicatory hearing officer want a test hole, we'll be happy to provide a test hole.
Yeah, and,
It's a simple matter.
okay, well, I've been asking for it for over a year, so I'd be very happy to see some test results. I also like looking in holes in the ground. Well, I guess the last concern that I have at the moment is the elevation and the fact that, you know, we don't know about the compensation as far as,
We did submit to the commission and to the DEP a worksheet showing all of the ground elevations that were taken, with literally hundreds of shots shown. So I don't think that there's any error in the accuracy of the instrumentation of the survey.
well, one concern would be the fact that most of your compensation, or a good portion of it, consists of prior fill.
I
that was
specifically
put-
chose that area because it took down the least number of trees.
I understand why you chose that area. I think it's probably
And
a
because
good
it had a
area.
lot of junk fill on there that I would just as soon
No,
not see on
I'm
the property.
not disputing that. I think that's the best area that you could have chosen for the compensation, but what I'm saying is it's all lumpy now. So taking a spot elevation here or there, you've got, you know, a dip here and a mound there, and I don't know how you resolve that as far as what elevation you've
We'll have a
taken
bill
it.
of lading from the trucking taking it out of there that will specify the number of yardage that's taken out. It may not be possible to get it down to the cubic foot, but it never is in practicality, which is why we generally compensate for more than is necessary. If you need 100 cubic yards, we usually compensate by getting 120, 130. In this case, we've got 10 times what we need. It's bound to exceed the amount, even if the guy who's doing the work is not particularly good at it. But we can get a bill of lading to show how much yardage was taken out with the truck. Each truck holds 10, 12 cubic yards. How many truckloads are coming out?
Aren't truckloads usually based on tonnage, not
I'm
cubic
sorry?
yards? Aren't truckloads usually based on tons and not cubic yards?
No, it's usually based on yards.
All right,
Depending on the type of material that you're carrying,
but we don't know what it is
but
yet.
if you were carrying soils,
Okay.
it's based on yardage. Soil weighs roughly 150 pounds a cubic foot, plus or minus, depending on the type of soil. So you can get the number of yards out of that. You can convert it to pounds without too much difficulty. But if you were hauling garbage, that's done by tonnage, by yard, by weight. If you're doing soils, it's done by yards.
You were usually
If I may, and I'm going to do a little show and tell here, because it seems to be skipping over everybody's head. But here's my trailer. I just put it in a floodplain. This is my compensation area up here. I just took this much soil out, hell of a lot more than what that trailer is. You see the problem with that?
I do.
Okay, good, because you know what? That's the biggest problem I have. It's not that we're providing 10 times, 100 times, or 1,000,000 times. It's that we don't know what the elevations are. And this area is so critical and so flat, and the act requires that the compensation be at the same elevations on a foot-by-foot basis. We don't, to this day, know, and I'm still stating that there's observable differences between the elevations on this plan and what was observed on that site. I would have requested a peer review. I would have requested independent engineering to verify those elevations. We still to this day, and I am not to this day satisfied that the elevations shown on this plan are in any way, shape, or form accurate. And that's the problem.
No.
It's not that you're providing 10 times as much or 25 times as much, is that it's what elevations are we providing them at? And that's the issue. And that's what I think we've never had an opportunity to discuss, never had an opportunity to go forward with the appropriate science and with the appropriate credentials and the letters at the end of the name for the people that could have provided us with that information. It hasn't been done yet to my satisfaction, and I still think it needs to be done because it hasn't. And that's my primary concern and my primary objection to the summary disposition here, is that I still think that needs to be done. And had it been done as part of the original order of conditions, had we discussed it, it would have been done. But it hadn't, and it still hasn't. That's, whether you're 10 times or 1,000,000 times, it's irrelevant at this stage of the matter. Whether you're providing 20% more or 50% more, it doesn't matter. If you're not at the right elevations, you're not at the right elevations, okay? And you know, that's the issue, or at least that's my issue. And I think that's a primary issue with the commission. So, you know, again, I think the commission should address that, and that should be part of our response. I know that you know, whether or not that, you know, whether or not that it sounds to me like that was not an issue for the PCC and for the Citizens Council, but it's still an issue for me, and I still think it needs to be addressed. So I think it should be part of our response. I think, you know, Commissioner Varnum has raised it. I know I've raised it. So, and I know Commissioner Biedron and several other members, you know, that aren't even here tonight have raised it. So, you know, I would like to see that as part of our response back to the hearing officer. And Commissioner Varnum, the floor is still yours.
That's all I have for now.
All right, Commissioner Parrish? All right, Commissioner Biedron?
So this, again, I wasn't here for the first notice of intent, and I don't think I would have approved it. Is this a construction trailer for a site that doesn't have any proposed construction on it?
Oh, that's the process, but it is a construction trailer.
Okay. So,
We're at the embryonic state of this potential project, so we're going to be here for a long time.
Could you speak into the mic?
Yeah, thank you.
That's the first step in developing this project. It was theoretically a year and a half ago to put this construction trailer in and have a place to really focus on the development of the project. It's a long-term project. We're going to be here for a long time, but that's ideally what we were trying to do a year and a half ago.
so like, why couldn't they rent a space somewhere in the city to design this?
Oh, we've tried. They own 11 acres. We tried to deal with the Elks, and we're still trying to get some kind of resolution with them. But this is where it just makes the most sense for development of the property to be on site, and that's the petitioner's right to have that.
This is like a lot of trouble for a design.
It is a lot of trouble that no one thought we'd have this when we came here a year and a half ago. You know, it just hasn't gone smoothly, but you know, it's a long-term project, so we'd like to get going. But I understand that, again, there's some issues that need to be addressed.
Okay, so for the record, because it does say mobile home, it said construction trailer, this is a construction trailer that's only used for construction.
Right, that's all been, I mean, that's what it is. That's what our,
Yeah, the floor is with
the only thing it's
Commissioner
going to
Biedron and
be, it's
Attorney
only going to have
Farrell.
electricity in it.
Okay, will there be a toilet in it?
No, it's not going to, no.
No toilet, no sink?
No water, so.
Okay. This question goes back to Mr. Erickson. So I am a professional engineer who augers a lot, and I'm just curious, if I was doing 4-foot sonotubes, I would never stop my augering at 18 inches, because I could just go down a little bit more and actually figure out actually what is there. Why would you stop?
Why would I stop?
Yeah, like, why, I don't understand why you would stop. 4 feet you could get down, but with a hand auger.
Because the auger is a hand auger, and I check the soil to verify what I already know. Before I dig the hole, I know what I'm going to find. It's rare when I'm surprised. The topography in that area is all
But why would you
flat.
stop? Why would you, right now, we're
Because I already
going
know
on what
it's
you
there.
say, and we're not really believing you. So if you said, I augured, and this is what I saw, and this is what it was, that would mean a lot more than you saying, well, I know in all my studies and my yada yada years. Why would you stop? Why didn't you go down 4 feet?
Because it'd be a lot of work, and because it
It's
verifies.
not, it takes 2 seconds.
I had already verified what I wanted to know.
No, because you only went down 18 inches, and these things are
No,
going
let-
down 4 feet.
Let me explain the geology of the area, okay?
You don't have to explain this to me. I understand. I'm a professional engineer. I get it. I would never stop. I would want to know. I don't understand why you stopped.
If I dug a 4-foot hole every time I dug a hole, I'd have arms like Popeye. And I obviously don't.
It just doesn't make sense. You're talking about, I would do a test pit if there was a high water table. Well, maybe if you dug down a little bit further, you would have figured out if there was water there.
I'm not worried about the water table because the footings can be below the water table. So I'm not even concerned about the water table for the most part. I'm not putting a foundation in.
Well, you stated earlier that you like to do test pits when there's a high water table. You could have dug a little deeper and saw if there was water there, and maybe that would have led you to do a test pit, and then we would
If
be
we
in a
go
little
around
better
to
position
putting,
right now.
when we get around to putting the temple in, we will definitely do test pits. But if I'm just gonna have a trailer sitting on the ground, I don't care if I have a 2-foot water table or an 8-foot water table. If I'm lifting it up above the ground, I don't care if I have a 2-foot water table or an 8-foot water table. It doesn't make a difference.
No, I'm saying you're contradicting yourself on what you said earlier, that you do test pits when there's a high water table. 2 feet down would equal a high water table, which would mean you
What
would
I
want to do
said
a test
was,
pit.
when you're building a single-family home, you don't generally do test pits at all. Unless you have a high water table, then it's a particularly good idea to do it. But
Now, that
not
would be a good
every
idea to
builder,
find out if we had a high water table here to do your test pit.
not every builder does test pits.
Or
for
you
a
recommended
single-family.
that with your soil experience, that if there was a high water table, which we don't know, because you didn't go down, that you would do a test pit, and then we would have some information, we wouldn't
If I
maybe-
was gonna put a foundation in, I would have done test pits.
You're putting
not-
sonotubes in.
I'm not putting a foundation in. I'm not gonna be in the ground. The only
I'm just
thing
saying
going
you're
in-
contradicting some of the things you're saying.
No, I think you're misinterpreting. The only thing that's going in the ground is the footing and the sonotubes, that concrete. The water table doesn't impact them at all. If I had a foundation, a living space down there, that would be significant to me. I don't. I never intended one.
All right, I'm still not set with your categorizing your soil
If I
based
make
on-
a suggestion, we can make that as a part of our response,
Okay,
okay?
yeah,
I mean, obviously, we're not going to agree
yeah,
tonight, so.
okay. And then, again, to go with Commissioner Varnum, I think the anchoring, the I-beam, all that needs to be added, a note needs to be added to the plans for us.
All right, Commissioner Gordon?
No questions.
All right, thank you. I'm not anticipating any further questions from the commission to anyone in the, yeah, just,
There's been an assumption made, I'd just like to clarify. We have no objection to concerns about compensation, and if you feel that compensation is made at the wrong level, I didn't mean to imply that we don't think it's a problem. We don't have the expertise to understand if there's further problem. Also, on March 8th, 2013, as part of a settlement purposes only statement, which has been declared public, Mr. Furlong has declared, I'd like to clarify the purpose of the trailer. We have discussed this issue with CKBM again. To be clear, they do not intend to use the trailer for sleeping. That being said, CKBM plans to use the trailer as an office for construction planning and business matters. It will also be used to receive members of the CKBM community and as a temporary place for praying, meditation, and religious activities when required. it would be disingenuous for us to suggest otherwise, and I apologize if that point were not absolutely clear.
Yeah, okay, thanks. I just, not to belabor that point, but that's really not an issue for this commission. It may be an issue for other, the building department or code inspection or, occupancy permits and stuff, but it's not really an issue for us, so. What I would like to do now, at least as far as have a discussion for the commission to hammer out a response, and what I'm getting a consensus, and I've got four main topics. One is concerning let me try and order them. I'll go from the bottom up. How's that? One is the suitability of the soils for support of the footings or the sonotube, or in the event of a high water event, flood event, whether or not the sonotubes will be sufficiently stabilized, on the site. The second main concern is the elevation of the top of the sonotube, and I believe we have a consensus that it should be at a 101.25 feet, and then whatever goes on top of that is fine, but that brings the top of the sonotube, or the minimum elevation of the top of the sonotube out of the floodplain, which is as part of our response. The third, again, this is concerning the trailer itself, would be that, we have information that the trailer will be anchored through various mechanisms to the ground, sonotube, bolts, I-beams, and whatnot. But in addition to that, the commission, in accordance with the original order of conditions, would still like to see a tethering, some sort of cable, tethering chain, whatever, that would be sufficient to, in the event, whether likely or not, that the trailer should ever, rip from its sonotube foundation and anchoring, that there be a secondary, a secondary tethering that prevents the trailer from becoming a floating, or prevents lateral movement of the trailer from the site. And then lastly, the commission is still of the opinion that had it had the opportunity, would have requested a peer review of the elevations as indicated on the plan, and is in disagreement with the elevations provided, and whether or not the compensation provided is at the proper elevation. The fact that it's at a 10-to-1 ratio, we have no objection to, or at least I have no objection to, but whether or not it's at the proper elevation, the commission would like to see some independent, whether DEP does it or an independent engineer does it, but would like to see some verification of the elevations as indicated on the applicant's original plan and plan that's being proposed as part of the summary motion. Those are the four main issues I'm getting out of the commission for our response back. And I'm going to open it up if there's any additional ones. But what I'd, as a matter of experience, would like to, you don't need to rebut every single point, and it's nice to focus on. Well, nice. It's prudent to focus on one or two main issues, and choose those as your strong points and the ones that you would like to respond to. I know that's not always possible, but I think if we can try and focus and narrow down our response, that it would be given more weight and more credence by the hearings officer. so. And again, this is just open response, so.
As far as the soils and the anchoring and the elevations, rather than just saying we want them done, I think the wording should be that you know, submitting engineering to that effect would be part of the order of conditions, because I don't know where else you could put that. You could say we want that, and perhaps Mr. Erickson would go down 5 feet instead of 2 feet with his auger, but I think we want a report and then perhaps a peer review report for some of these issues, especially the anchoring and the elevations, I think.
Do you also want to include environmental testing, because you guys are concerned with the site being hazardous?
I'm having trouble with
Do
this.
you want to include environmental testing of the soil, because you're concerned about it being contaminated?
If that's the pleasure of the board, I'm less inclined to do that at this time. I feel that it may be more prudent to do that as in the event that the project goes forward to something more substantial on the site.
Yeah.
But I think at this point in time that the disturbance to the site is relatively minor.
Yep.
That it's not as critical an issue. But again, that's just me, and whether, you know, there's four more of you here other than me, so.
But on the other hand, I would think the applicant, the proponent, would want to know if they have a serious issue with parts of their site
Yep.
before they spend a lot of money on it. Because certainly remediating any toxicity would cost a lot of money, too. I can see the chairman's point that if they're not disturbing that area, then it might not be necessary right now to test, but certainly the next notice of intent that comes in, that would be part of what I would want to request, is testing for hazardous materials.
I would have to agree with the chair that I think it would be premature to do a toxicity sample right now, since it is just the trailer right now, not the proposed site in the future.
So what do we want to propose? Do we want to propose like 2 10-foot borings, or, I mean, me personally, I always go down a lot, usually double than what I'm doing. So I would I would go down at least 8 feet if I was putting in 4 feet of concrete.
Now, would you feel that that would be necessary for the suitability of anchoring the sonotubes to the ground?
Yeah, why not?
Such that they were stable and suitable to support the,
Yeah, you don't just go on the layer where you're installing something. You go even deeper to make sure what you're putting it on.
you feel that's a reasonable request? I mean, what we're doing is we're advocating our response in the hopes that the hearings officer will adopt our position and make it a part of an order of conditions. Assuming an order of conditions issues.
Yeah.
I mean, the current state of the matter right now is that there's a superseding denial. So that there's obviously an appeal right now to issue, an order of conditions, so.
Yeah, I would recommend that we do two 8-foot deep soil borings. One on each side of the trailer.
All right. And that would be in proximity to the trailer area?
Yes.
Yeah.
Yeah, I'd want them both in the trailer area.
Oh, is that something, Commissioner Biedron, that in your dealings is somewhat standard in the industry?
Yes.
All
Yep.
right, okay, so it's, all right, do we have any, I suppose we can work out the wording as far as, and leave it up as far as we have information about the anchoring, but also additionally tethering. Do we have any further, let's take that part at least. Do we have any further comments to any specificity of response with respect to our position as to tethering, additional tethering of the trailer to the site, such that, any floating or lateral movement in the event that it would rip from its foundation or anchoring?
Yeah, like, what are we gonna connect that to?
Well, I mean,
Another sonotube?
it could even be connected to the sonotubes that are there. I guess that the sonotubes, I'm not going to say I'm an expert boater, but I've been on enough boats and I've placed enough moorings in the ocean to know that it doesn't take a huge mooring to keep a rather large vessel from moving, provided that the tether that it's attached to isn't shorter than the water level, because the boat will literally pick the mooring up off the floor. The anchor doesn't need to be huge. It doesn't need to counteract the displacement of the water. All it needs to do is to prevent lateral movement of the vessel. And even a rather large vessel, it doesn't take all that much to prevent that. So even if for instance, a sonotube were to be ripped from the ground for some reason, I would imagine that the weight of it itself would be sufficient.
So would we wanna,
So that, a tether, it wouldn't have to be all that long. It wouldn't really even need to be all that strong. It would just need to be something that's not going to cut, something that's not going to fray, a steel cable, for instance, or chain.
yeah.
Something that's not going to break.
Like some sort of footing?
Yeah,
or
it could,
footing sonotube?
into an eye bolt. I mean, I'm not,
Yeah, I'm not.
I'm not an expert, just some method of tethering it to some, it's one of the sonotubes, or, such that, or maybe both ends of it even, I don't know. So
Yeah.
it's not gonna float away. That's all in high winds or some lateral, movement of water. I mean, I leave that up to the experts to do it, but just that there's some, some sort of secondary tethering to prevent the lateral movement of the trailer in the event that it was ripped from its foundation.
Aaron, have we ever done this before?
As a part of the building permit application, the building commissioner will require engineered plans, plans that are signed and stamped by an engineer to show that they can withstand lateral movement in a floodplain. So it's not uncommon, and probably would be submitted in a conversation I had with the building commissioner that will be required with the building permit application.
To do an additional tethering?
Well, that it would be designed and stamped by an engineer that stated that it would withstand the forces of storm damage during a flood event. That would be a requirement of the application.
Would that
So I
engineer,
guess in essence, what the commission might be looking for, and correct me if I'm wrong, but just to get to a resolution, that those plans would be presented and submitted prior to that point.
Yeah.
I'm
for
just,
the
is
conservation.
that the same professional engineer that's gonna stamp that we're worried that his elevations are wrong?
Now, is this,
Structural engineer.
The what?
Yeah.
It would be a
It will be a
structural
structural engineer, okay.
now, would this be something that's, Aaron, let me ask you this, is this, apart from this whole process here, and apart from the appeal and apart from the process
Right.
proceeding before the DEP, is this something that the building department in the city of Lowell would require in addition to any occupancy permit or placement of this trailer on site?
Yes.
So whether we took action on it or not, it's something that would be ancillary to any action here?
Correct.
So if we didn't address it at all, it's something that another department in the city would address?
Correct.
All right, so it's,
And I was actually going to bring it up, being in building industry, it would be no need for us to actually add a tether to this, in my opinion, so. I didn't get a chance to talk about it, but.
now you're saying as far as the commission, there would be no need, or?
Yes.
as part of the building
As far as
industry.
as far as the building of this, I think he kind of touched on it a little bit earlier. There's going to be a need for them to provide, information that says this is going to be able to handle this amount of stress, and it's going to include waves and what have you.
So in the event that it were to come float, the anchoring
Just like a regular
system is
house.
going to have to,
Just like a regular house.
all right,
Yeah.
okay.
Absolutely. And that's really the only thing for myself that I do not agree with, is adding that, but everything else, I'm actually with everyone else. I think for me, if we want to focus elevation confirmation and peer review, and then kind
So
of everything after that.
So, Commissioner Parrish, correct me if I'm wrong, you're saying that tethering is sort of overkill here?
Yes.
Unnecessary overkill?
Yes.
All right, okay. Well, that's two people that have said that, so. Well, I mean, then that changes my opinion, then I'll let the experts hammer that out, but if you feel it's unnecessary, then,
Yeah, I mean, I think it's a great idea, but it's going to be sorted out by someone else. Mandatorily sorted out by someone else.
all right, well, and again, that's,
But you are not sticking another sonotube in the ground and putting some sort of bolt on that or whatever is pennies compared to the damage.
yeah, well, and again, that's the way I looked at it too originally, was it's just it's putting a leash on your phone so someone doesn't take it out of your pocket. It's, a $5 part,
And I agree, like I said, I don't think there's an issue asking for it. However, it's really not needed. I mean, it's just not needed.
Yeah, but look at it this way. Look at it from the sake of you live next door to it and you've got the 70-foot potential boat in your neighborhood that is blocking an evacuation route. Wouldn't you feel a bit more comfortable, I suppose, if in the event that it were to become waterborne, that it's not going to go very far?
I would say if I hadn't spent half of my career in the building industry, yes. But there are people that are responsible for making sure that doesn't happen for any
Okay.
structure that's placed on the ground, above the ground, in a residency, so,
All right.
yeah. Aaron, you agree?
I know it's a part of the process for the building permit. So.
Well, Aaron doesn't get a vote, so. All right, are we all in agreement with respect to the top of the sonotubes to be at 101.25 feet?
Yes.
The minimum top of the sonotube, all right, so that will be part of our response.
What'd you say for a number?
101.25 feet. No lower than 101.25 feet, adjusted to the City of Lowell datum. Okay. So that's one of our responses. The second response speaks to, we would like to see the hearing officer adopt, if in the event that an order of conditions is to issue, that the applicant to provide two 8-foot test borings and the suitability of the soils to support the sonotube or other foundation that is to be used to support the trailer. And appropriate, an appropriate engineering to be provided to the parties.
Yeah, could we say like the boring logs be sent to the city for review prior to any start of
Right,
construction or?
right,
Yeah,
right.
I would like to see what the logs come back as before.
And lastly, that the commission, that the Lowell Conservation Commission is of the, I don't know if we express this as our position, but of the opinion, but our position is that the applicant be required to furnish a third-party review or additional engineering, civil engineering to verify the site elevations, specifically with respect to the area of the trailer and the area where compensation is to be provided at this time, to verify the elevations as provided and as proposed, I should say, on the plan that's being proposed as part of the summary disposition. we're not, and it's not the commission, we're not an objection to the compensation area or the placement of the area. We don't have an objection to the amount of compensation being provided, however, and provided that the elevations in fact are accurate, the commission does not have an issue with the compensation, but we're still of the opinion that had this been a part of the original process, that we would have requested an independent review of the, independent expert review of the elevations. And did not do so specifically because it was not an issue before the commission. And we feel that that's a substantial change and a significant unanswered issue, as are the rest of them. But does that address all our issues in our response?
The only thing, are we gonna do the anchor, the tether, or do we all?
Well, yeah, I mean, and I've had two experts tonight tell me that it's unnecessary, but I agree with you, Commissioner Peter. It may be unnecessary, but I think it's, penny wise, pound foolish here. It's such an insignificant thing to run a cable around it and keep it from floating away than to just trust.
I think we might as well ask for it and then
Yeah.
let someone else eliminate it if
Yeah,
it's not
let someone
necessary.
else, yeah. So let's ask, I'm in, and are we in agreement on that? I don't, because this is, we're kind of going to be putting this as a motion.
I support it.
Okay.
I'm just
All right,
making it for
okay.
the record that
All right.
it's.
Yeah.
So we have 4 main points going back. Do we have those? Okay. Now, we have the one final thing. Now I'll speak to whether or not we should file jointly. I appreciate you folks, all your input, I really do, but I'm of the opinion that it should not be a joint response, and not because we disagree with you at all. I think we have very similar concerns. I just think it sets a bad precedent for the Lowell Conservation Commission to jointly respond with private parties in an act of action. That's just my own opinion. I'm a little, I guess, chagrined by the DEP's joint response with the applicant, but I'm not going to speak for the DEP. I don't think it adds to anyone's position. I don't think it detracts from anyone's position. I think the hearing officer will be able to determine, they have similar issues, or, they have the same issues, but they may disagree on one thing or whatnot, but making it joint forecloses your ability to disagree with us on minor points. It also forecloses our ability to disagree with you on a minor point or a major point. It allows you to craft your own response as you see fit. Whether or not it's very substantially similar to ours is fine. The hearing officer will see that, okay? And again, our response will be part of the record and will be available to anyone who requests it. And again, that's just me. All right, I don't feel that the commission should join in a response, and it's not because I don't like you. It's got nothing to do with that at all. I just don't think it's a proper thing for the commission. I don't think it helps. I don't think it hurts. It's a neutral. I don't think it adds to anyone's position. I don't think it detracts from anyone's position. I just don't think it's necessary. And because I don't think it's necessary, I don't think we should do it. That's my own position. I think we should probably take a formal vote on it because it was a request and we did spend some substantial time. So, Commissioner Parrish?
I propose to deny the request. for us to join.
So we have a motion to deny the request for a joint response. Do I have a second?
Second.
Okay, seconded by Commissioner Gordon. Any discussion?
I can see your point about, you would almost have to be perfectly aligned in order to, and I know we've only got 4 points and the neighborhood did have 6, or the abutters, whoever the other party is. I don't think we should deny them the ability to say that they agree with the Lowell Conservation Commission as far as the 4 points that we brought up, if that's essentially the case. But I almost think it might be a stronger if 2 of the parties actually are requesting the same thing, although separately. So I'm basically, could go one way or the other on this, but I can see how a public entity could be perceived as taking sides if we do align with a private entity. But like you say, I don't think it will strengthen either case, and I almost think separate filings would strengthen the requests if they're made from 2 different places.
Any further discussion? All right. Do we, all in favor of the motion? The motion was to not join with the private entities in a response. That doesn't mean we're in disagreement. It just means you can, and again, I know you outlined 6 and you had, but that doesn't mean you can't change. You can do whatever you want. I mean, and as Commissioner Varnum had indicated, there's nothing that even stops you from saying, we agree with the Lowell Conservation Commission's position. But we would like to do more too. I mean, it's, and there's nothing that stops even the applicant from doing that too. I mean, this is the nature of this. Any further discussion? No.
Yes.
Commissioner Varnum.
When you just said it doesn't prevent the applicant from doing that, I know that the proponents agreed with a lot of what we were concerned with tonight, and I'm wondering if there's some kind of a ability or a measure. I know they've already submitted their response with DEP, I think. I'm not too familiar with the steps here, but I wonder if an additional response could be made to say that they agree with the points that we did come to an agreement on, such as the anchoring. Let's see. I think you agreed to the test pits. I'm not sure. But that would certainly make it easier for us to get the things that we were in agreement about if the proponent also was in agreement with them. We just want the order of conditions to be a document that's going to work.
Right, and it's our hope that we're going to work with the Conservation Commission, so we're going to review everything. I'm just not sure procedurally, I think, if we're going to supplement a response. If we can, I have to look at there was a scheduling guideline as to who had to submit what by when, but I'm certainly going to address the things that we agreed to, and then have a discussion with the petitioner as to these other ancillary issues, because going forward, at some point, you're going to ask these things, and they're going to have to be done at some point. So to see what we can get done and when we can get those things done. But we agree on the anchoring. I believe the test borings weren't going to be an issue.
And I think the elevation of the trailer is a little different than what it's stated in the documents now that we put the I-beam in there.
So I plan to discuss this and see what we can narrow narrow down. We certainly want to narrow down as many issues as we can. And, you know, a lot of these issues aren't insurmountable. So we have every incentive to get these things addressed because they're going to be addressed at some point. So, you know, things that are easily addressed, the elevation on the map, the anchoring, the test boring, you know, we can address those as soon as possible. That's kind of what we did in July when those issues were raised. We addressed what we could, even though it wasn't really germane to what issues before the hearing officer going forward. It's germane to the project, so you know we have an incentive to do that. So that's my. You know, I just don't see an issue with addressing as many things as we can.
All right, all in favor of the motion, signify by saying aye.
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 Aye. Opposed? All right, the ayes have it. So the commission will not join. It doesn't mean we're in disagreement. It just means we're not going to craft a joint response. Now, as far as, do we need to make a formal motion for our response? I mean, I think we're just making our response. I think we've already outlined it, so.
Yeah, I don't think it would hurt to just take a quick vote on the 4 main points.
All
I mean,
right.
obviously, the language will be worked out going forward, but I think it would make sense to take a vote on the 4 main points.
We don't need to go over them again. Can we just make the motion as outlined by the chair?
That's absolutely fine by me. It's on the record as such.
I'll make a motion to approve what was outlined by the
All right,
chairman.
by Commissioner Bedrin, seconded by
Second.
Commissioner Varnum. Any further discussion? All in favor signify by saying aye.
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 Aye. Opposed? The ayes have it. All right. And we don't have anything further? All right. Do we have a motion to adjourn the special hearing? By Commissioner Varnum, seconded
Second.
by Commissioner Bedrin. All in favor signify by saying aye.
Aye.
Opposed? The
Aye.
ayes have it. Before everyone goes, I would just like to really sincerely state that I appreciate the input. Just for my own self, I know sometimes it seems like I go back and forth on issues, but what you folks say, it means something to me, and it helps. The other thing I would like to say, and the meeting's over. This is, it's on the record, off the record. I don't know what it is at this point in time. I know it sounds like, at least for me, that I may be against what's going on the site or what's being proposed on the site, but to me, seeing a temple here would be infinitely better than some sort of development, provided that the site is developable under the Wetlands Protection Act. And I think it needs to be stated that we've had a lot of difficulty just getting a small trailer on the site. This is one of the largest flood storage plains in the city of Lowell. It's critical, and just so the applicant knows, this commission is going to scrutinize, and I know Mr. Erickson characterized it's difficult to figure out a cubic foot here, a cubic foot there, but just so you know, we're going to be scrutinizing every tablespoon here and there. It's that important, and it means a lot to the folks that have been through this entire process. They're the ones who have lived through 2 significant floods in the last 5 or 6 years. And you don't have to go back 100 years for the other significant floods. There was one in 36 and one in 38. It is important, and it is critical. That being said, the artist concept plan that I saw in the Lowell Sun, last year, I thought it was spectacular. I would love a structure like that in the city. I really would. But you have to be sensitive to where you're putting it. This is a really special place. It's special to you folks, it's special to your neighbors, and you gotta work together. You gotta figure it out, because if it's spending this much time and effort just for a little trailer, can you imagine what it's gonna be for a building? All right. Okay.
Thank you so much.
Good night.